All right, this is opening the call to order for the meeting of the Personnel Board for October 21st, 2025. In attendance, we have John Schwinn, Chief Ryan Hawk, Matt Shipley, Eric Fisher, Steve Corbel, Rita Martin, Brian Snyder, Joe Wall, Amy Weirspon, Michael Witherall, and June. Drenovich, thank you. And open it up for public comments on the agenda items this time.
Ellen Wright, are we doing addresses? Okay. Ellen Wright and my WRIGHT. My question about the appointment of a solicitor. I thought the personnel board had a solicitor, and when I looked at the minutes, I didn't see that there had been a loss of solicitor, that one needed to be appointed. So that was, perhaps I missed that in prior minutes. So that was my question. Thank you.
Thank you. All right. Any other public comments? All right, so we'll 26th and also September 16th. I have a motion to approve the minutes.
So moved.
I'll second it.
All in favor?
Aye.
Opposed? All right, the ayes have it. New business, appointment of solicitor. Can I have a motion to approve Mike Witherall as our new solicitor?
Second.
All in favor?
Aye.
Aye.
Opposed? All right, so Mike is appointed as our new solicitor. And now we're going to conduct a hearing for disqualified candidate. Mike, you want to take over?
Be happy to. My name is Mike Witherall. I'm now, as everybody heard, is the solicitor for the Personnel Board. And today we have a hearing for a disqualified candidate. Is candidate Lippert here?
Yes, sir.
If you stand, please, sir. Give your full name.
Joshua Michael Lippert, Lippert.
Okay, thank you very much, sir. And this hearing is a local agency hearing. You can sit down. Relax. Where the rules of evidence are relaxed, any relevant evidence will be submitted. You'll have the opportunity to cross-examine anybody who testifies, and you'll have the opportunity to testify on your own behalf. I take it you do not have counsel here today, is that correct?
My counsel could not make it. They're in depositions.
Okay. And at this point, this is the town of McCandless had requested disqualification. And Steve, it's up to you as the solicitor to provide us with the information on that.
Thank you, Mike. In front of everybody, in front of Mr. Shipley and Ms. Martin, there is a pile of binders. Prior to the hearing, I asked Mr. Lippert to take a look. And so I'm asking for this to be entered into the record. And I'll read the documents that are in the record for the court reporter. The first exhibit is Mr. Lippert's 2025 police officer application. The second exhibit is a open records request form submitted by the town to the Metro Nashville Police Department. Exhibit 3 is a waiver and release for background investigation dated May 20, 2025, signed by Mr. Lippert. Exhibit 4 is a set of disciplinary records for Mr. Lippert from the Metro Nashville Police Department. Exhibit 5 are additional employment records for Mr. Lippert from the Metro Nashville Police Department. And number 6, exhibit 6, is a set of performance evaluations for Mr. Lippert, again from the Metro Nashville Police Department. Exhibits 4, 5, and 6 were all received from the police department in response to the open records request. Exhibit 7 is a letter from the Personnel Board regarding his disqualification. That letter is dated September 22nd, 2025. Exhibit 8 is an email of the same date, September 22, 2025, from Mr. Lippert to me, indicating his intent to appeal. Exhibit 9 is an email from Mr. Lippert on September 26th, 2025, again to me, formally filing an appeal. Exhibit 10 is a series of emails dated September 29 regarding my receipt, whether or not I received his September 26th email. Exhibit 11, again, a series of emails where I responded that I did receive his appeal. Exhibit 12 is Article 37, Personnel Board of the Town of McCandless Code of Ordinances. Exhibit 13 is Ordinance 1554, which amended Article 137, and Exhibit 14, Ordinance 1558, again, further amending Article 137. And I included those because the online Article 137 has not yet been updated to reflect those changes that have been made in the last 9 months. So that is the record that we're submitting. Mike, if the board or you and the board would permit, I'd just like to make a quick opening statement to explain the town's position. And then, Mr. Lippert can, as far as we're concerned, Mr. Lippert can, present his objections to the disqualification. So at the end of the day, this is a pretty cut and dry case. As the board knows, Mr. Lippert was disqualified because of his application, which is tab 1, exhibit 1. Question 18 asks if he had ever been subject to disciplinary action while in any position. If yes, please explain and provide the name of the employer and approximate date. Mr. Lippert answered no. If you move to tab 4, this is Mr. Lippert's disciplinary record. It's the largest tab in the binder. It's 253 pages long. And there are a series of disciplinary actions, at least 11 that resulted in anything from an oral reprimand, a verbal type counseling, to written reprimands, to suspensions, several suspensions that added up to over 10 days of suspended time while he was employed by the Metro Nashville Police Department. The town's position is that by answering question 18 in the negative, Mr. Lippert made a material misstatement on his application, and according to Article 137, our ordinances require that candidates answer honestly. Specifically, Rule 203 in Section 137.05 indicates that if there's false or incorrect information, the application will be void, and any subsequent action taken upon it would also be void. Additionally, Rule 206 says that the board may refuse to examine or may refuse to certify any applicant who is found to lack any of the minimum qualifications as prescribed and adopted for the position for which Mr. Lippert has applied. Here in section or Rule 202 of the Personnel Board rules here, we require all of our candidates in the town of McCandless, and our view is that making material misstatements on your application and one that includes over 11 disciplinary actions, it's not an example of, oh, I forgot that one time I received there are 11 actions in here that occurred over several years. that this is, in our view, a pretty strong sign of the type of character that we do not need or want in our officers. And the rules here allow us to disqualify him for those reasons. Secondly, I guess our second argument would be in the letter that was sent to Mr. Lippert regarding his disqualification, in which that is in tab, in your exhibits here, that would be exhibit in tab 7. And according to our rules and regs, we provided Mr. Lippert with a specific method by which he was to appeal his hearing. And this is in the last paragraph that he has to, and in order to exercise his right of review, he has to inform the personnel board in writing of his request to appear. And it has to be submitted to the personnel board by email and by regular mail addressed to the following. And that address was to me as the town attorney. And although I did receive an email from Mr. Lippert, I did not receive a letter from Mr. Lippert to this appealing the matter. So from a purely technical procedural matter, our argument is that his appeal is defective just from that procedural issue. Although at the end of the day, beyond the procedural issue, on the merits, our view is it's pretty cut and dry. And we think the board can make a call on both if it would like to do so. I think that's pretty much it. As to where we are here, I do not believe that we need anybody to testify from the town. I think the documents speak for themselves. And I'm happy to, Mike, if you're okay with that, to yield the floor to Mr. Lippert to address his appeal.
Well, first we'll accept the exhibits 1 through 14 into evidence. And Mr. Lippert, give the opportunity if you have any questions for Mr. Corbo who presented this, or if you have anything you want to present to the personnel board regarding this matter.
No, I did not bring any documents, so I apologize for that. Thank you, Mr. Corvo, for the synopsis. Do I have the floor? My floor?
Yes.
Okay, thank you. Page 9, question 18. Did not intend in any way, shape, or form to obscure my record from the Metro Nashville Police Department. This is a simple misreading of the question. You have my sincerest apologies. I take responsibility for that. The instructions of the packet did say, without a doubt, to read thoroughly and carefully. I did not read that question as thoroughly and carefully as I thought I had. I stand by my record, to be completely honest. I'm now 40 years old, father of 2. That record has made me into the man that I am, good and bad. So in exhibits 5, 6, 7, 8, whichever they are, that Mr. Corbo gave to you, it is incredibly one-sided, only focusing on the negatives in my disciplinary file. There's no mention of the numerous times that I was named precinct officer of the month, department-wide officer of the month, the number of advanced trainings that I received as a member of Metro Nashville Police Department. I served in both patrol, a proactive enforcement team that we called Flex, crime suppression unit, which is a precinct-based narcotics, SID, specialized investigations, and then finally with records. I was assigned to records following a 2017 OIS officer-involved shooting. That's why I personally stand by my record. You don't have to submit a request for Metro Nashville to get my disciplinary file. You can Google it and it's all public. I stand by that. I stand by the mistakes that I've made because it's helped me to become the person that I am today. And I kind of like the person I am today. Without a doubt, I was a young officer in a Metropolitan Police Department in which CALEA has told them numerous times through the accreditation process that they are too heavy-handed with discipline. And that is directly from a associate that I went to the academy with that was on the accreditation unit. Obviously, he's not going to fly up to testify for something like this. Furthermore, the Metro Nashville Police Department operated very differently than Pennsylvania-based police departments. Here in the Commonwealth of Pennsylvania, police officers have a statutory right to avoid suspensions for, pardon me, let me rephrase that. In order to be suspended in the Commonwealth of Pennsylvania, you have to meet very specific criteria. I had no protections in statute at the Metro Nashville Police Department. It was a very coercive environment. I don't expect any of you to have done any research on it, but right now the Attorney General's Office of the state of Tennessee has an open investigation into the disciplinary practices of the Metro Nashville Police Department going back a number of years. Everything from, favoritism, avoiding repercussions for high-ranking officials based on age, gender, political affiliation, religious affiliation, and so on. None of that is, I'm not saying any of that to dissuade you or to try to say some of these mistakes were not my fault. They absolutely were. I was working in a department where I thought at the end of the day that the work I was doing was more important. And as I aged within the police department, I matured as both a man and a father. I realized that the method was far more important than the result. It was actually a question that I answered in my interview to the panel. One of the very first questions. It took a while, obviously, for me to figure out that the policy side of things was more important than the end result. And again, I stand by those decisions because it made me who I am today. Again, all this information came to light as far as following an OIS. To put it in context so that you all understand, within the Metro Nashville Police Department, in order to be terminated for bad conduct, you have to receive 31 suspension days in a 12-month period. What's not listed in that packet is I took 20 suspension days over the course of 8 years. Everything from being, I missed a court date, to my largest suspension, which was an 8-day suspension for decision-making for flat out what my partner did.
I didn't hear you, sir.
For flat out what my partner did. And if the department had requested any additional documentation from me at any time, I could have provided as such to demonstrate, to further demonstrate the environment that I was working in. Again, not to try to dissuade or to pass blame, because I certainly made some mistakes. I was in Mr. Corbell's letter, he states definitively that I took over 10 suspension days for excessive force. That is patently false. Much like with Chief Hawk can attest to this, when you file a criminal complaint in the Commonwealth of Pennsylvania, you have to be very specific about the charges that you're the charges that you're laying against somebody. Within a Metro Nashville Police Department, those same principles apply. You can't throw the word excessive force or the claim excessive force when the internal process of the department itself found no issue with the use of force itself. I took an 8-day suspension for what Chief maybe he can explain it to you. It's called the Pennsylvania versus Mims case. I had a young man coming out of a high crime area and matched the description of robberies that was occurring in the area. He was driving a rental car, which was consistent with the MO of the offender. He was slow to stop, immediately verbally combative. I requested additional officers. When it comes to police work, once you have additional officers, certain folks take certain roles. I was acting as the contact officer, meaning I had primary contact with the offender, the driver. I had no less than 3 additional officers that were there with me. The young man, I had specific articulable facts at the time to request him to step out of the vehicle for my safety based on the totality of the circumstances. He refused to do so. My partner, Wes McClellan, reached in and yanked this gentleman out of a car, which is in accordance with Pennsylvania versus Mims. There was no punches thrown. There was no taser. Physically removed from the vehicle because he was resistant to the lawful orders of myself and my partner. I only became physically involved when he struck my partner in front of me. Recklessly, I would, to be clear, he flung his arm, struck my partner. That's when I became physically involved. I took the 8-day suspension for my partner because he was related to a high-ranking member of the police department. Point blank period. And I would feel free to forward any copies of any documentation that would be requested to back that up. The environment in which I operated in Metro Nashville Police Department was very, very forceful in the way that if you used your rights to appeal these interdisciplinary or interdepartment disciplinary actions, you were then targeted for further action. So for example, it's the day of court. That's a 1-day suspension. If I would have fought that, the department would have come back in turn with 3, 4, 5, 6, whatever the case was, however many days suspension that they wished to put on somebody. You didn't fight that internally, because once you did, you were blackballed. Under advice of my then lieutenant, the very first time I took a suspension day for anything, I was told by my lieutenant, Melvin Brown, do not fight this. And after I left the Metro Nashville Police Department, that same gentleman reached out to me and apologized and informed me that he wished I would have fought. Because once you have a reputation within a police department, and it's the culture of law enforcement. Once you have a reputation, you are going to be targeted for further action, point blank period. It just isn't how it is, especially as a Northerner in the South, a Catholic in the Baptist South. I was seen as a Northerner as being brash, arrogant, whatever the case may be, because I came from a different societal norm than a lot of the people that I was dealing with. It got to the point where I, as an officer, when I would pull somebody over, and part of my language, I would say, listen, I'm not an asshole, I'm just from up north. And people would immediately relax because they know that, because I found that as a way to build a rapport with folks, to demonstrate that, hey, I might come off this way, but that's not the case. I was raised differently. My disciplinary file began with Metro Nashville Police Department after my sergeant found out that I was a Catholic and that I was heavily tattooed. Not heavily, but I had numerous tattoos. Shortly after that, I was being put in for things that he was aware of for months, minor things. So again, 31 days total in a calendar year to be terminated. I took 20 suspension days over the course of 8 years, and I received suspension days for things that I received Chiefs coins and Officer of the Month awards for simultaneously, one in one hand and the other. HR would laugh because when you go to sign for your days, they say, how many Chiefs coins have you got? It was the price to pay of doing business, so to speak. Now, as a board, I completely understand why you see that and why you would be hesitant, and especially the chief. Nothing but respect, sir. I understand the position that you are in as the head of a law enforcement agency and seeing that kind of baggage. The grand scheme of things, I think, are important here. When you're done here, if you want a good read, I would Google Nashville Police Green Mile. So in our old headquarters, when an officer was accused of anything serious, that officer would be decommissioned, gun and badge taken, authority taken, and they would sit in the front of the police headquarters next to the sex offender registration window for 8 hours a day as a public humiliation for their alleged bad conduct. If anything I had done within my career was egregious enough to have ended up on the Green Mile, I'd be the first person to agree with everything that you're saying. And this is all circumstantial. I understand that you guys don't have access to all this information. I never was on, quote unquote, the Green Mile. The only time I was ever decommissioned as a police officer, had my gun and my badge and my arresting power taken, was for the 8-day suspension in which I took from my partner. Again, I would gladly provide that copy of that file to anybody, because that 253 pages, that's really light, to be honest. My shooting review of the officer involved shooting I was in 2017, I believe was about 800 pages. I was cleared both at the state, local, federal level. I wasn't even sued. That's how clean that was. Now, I understand as a personnel board and as a representative of this community, why some of that information would give you pause. The purpose of me coming here and appealing this decision was, one, because it was a minor mistake, a misreading of the question on my part, and I take full ownership of that. But I never intended in any way, shape, or form to materially or in any other way deceive or mislead the McCandless Police Department. I got out of law enforcement for a number of years. Even after all that, after the social media, the threats to my life, the threats to my family, had to move. First person in the state of Tennessee to buy a house under a trust because of what was happening. It's now a felony in the state of Tennessee to do what people did to me and my family. And at the end of the day, I still want to serve people. I've paid probably the third highest price there is in this field, short of serious injury and death. I've watched my friends die on this job. I've watched them burn to death in a patrol vehicle pinned between a suspect's vehicle and a telephone pole. And I still want to be here and do this. Am I perfect? Far from it. But I'll tell you right now, those 11 disciplinary actions that Mr. Corbell is referred to and that you have access to in front of you, one, I would say take that with a grain of salt, because the winner gets to write the narrative after a war. I think everybody kind of understands that one. So they get to write it up how they see fit, because I couldn't fight it. I was told not to. And then I'm here because I have a passion for protecting people. Nothing I've done project management and construction for a number of years. Nothing I've done suits me like this. And if you ask anybody that I listed as a contact, anybody I worked for, you ask any of the people that wrote me up in this binder, if I wouldn't be the officer that they would want standing next to them if something bad happened, I would be absolutely shocked. Because yes, I have my faults, but I would also argue to you and to anybody else that sees my record and has pause, that as a 40-year-old man who's been in and out of this field now, who's paid the probably third highest price that there is to have for doing this job and do nothing wrong. I was cleared. Couldn't even catch me speeding that day. That's how clean it was. I know what it takes. I know that the sacrifice. I didn't try to mislead you. I stand by my record. I am sorry that I did not thoroughly read that question. And I understand Mr. Corbell's perspective. I understand your initial decision. I understand Chief Hawk's desire to not have the baggage. The point of me coming to this appeal was hopefully to ask for some grace. I made a mistake. I own it. I misread the question. But I put my record up against any young, brand new person out of the academy, because guess what? I've made just about every mistake one of those young recruits is going to make. I've already learned. I've learned from my mistakes. I have the wisdom as both a father of an older gentleman, as a combat veteran. I'm not asking you to overturn anything, to look the other way on anything. I stand by my record. If you want to ask me anything about anything in that file, I'll tell you every detail. I took a polygraph for the city of Pittsburgh this morning. I'll take another. I'll take one every day, because that's what this job means to me. And that's what helping people means to me. So I do sincerely apologize. Now, Mr. Corbell brought up a technicality at the bottom of the letter that he referred to. the board met, what was it, September 16th, sir? I got my email. I'll confirm.
I think.
Yep, September 16th, 2025, the Personnel Board voted unanimously. And based on that information, I wouldn't blame you either. When you control the information, you control the narrative.
I can't hear you, sir.
When you control the information, you control the narrative. And again, no fault of Chief Hawk. I completely understand his perspective. If I was in his shoes, I'd probably have the same pause. All I wanted from this is a fair chance to try to get back into doing the thing that I was put on this earth to do. But if we want to get into technicalities, Pennsylvania Sunshine Law requires for a special meeting to be held 24 hours advance notice, to be posted at the place of the location, and to be published in a paid newspaper of significant circulation. Correct, sir? Mr. Corbel? Is that correct? Is it?
I mean, I don't think I'm on the stand, so.
I mean,
You can-
am I not giving?
make
I can
your-
advise the board as to what the sunshine law is. You can go ahead, sir.
So in preparing for this hearing, unfortunately without my counsel, because again, they're in depositions, the Pennsylvania Sunshine Law clearly states that for any official action to be taken at a special meeting, that meeting has to be posted no less than 24 hours in advance notice at the location of where the meeting is to be held, and placed into and advertised in a newspaper, a paid newspaper of general circulation. I'm paraphrasing. I've tried to check to find the advertisement in the paid periodical of general circulation. From my research, I think I found that the Pittsburgh Post-Gazette is typically who the township of McCandless uses to post these public notices. I searched the Pittsburgh Post-Gazette website. I found the notice for today's hearing. I found no record on the Pittsburgh Post-Gazette's webpage of any notice given prior to the September 16th meeting. I then went to a website called publicnoticepa.com, which tracks all public notices published throughout the state of Pennsylvania. I've got 9 pages going back the last 52 weeks of public notices that were put out by the township of McCandless. No notice for the September 16th meeting. Under the Pennsylvania Sunshine Law, any official action taken at a meeting that is not consistent with the Sunshine Law would be null and void, if we want to get into technicalities. So if the board did not properly advertise the special meeting on September 16th in accordance with state law, then any official action taken at that time, i.e. my disqualification in general, would be null and void. Let's see. As far as subsection 206 of the township code, Chief, can I ask you a couple questions since you've completed my background? Thank you. Is there any indication that I am a habitual user of intoxicating liquors and or drugs?
I'm going to object that we're not making that argument. We're making the argument that there was a material misstatement.
What relevance does that have to this hearing? This hearing is about your disqualification for misstating on your application. So what relevance would that have, sir?
Well, Mr. Corbel quoted subsection 206 of the township code in reference to my disqualification, saying that I did not meet the criteria of subsection 206.
The good moral character.
The good moral character, correct, yes.
That's the only section.
Correct, so.
Nothing around intoxicating liquors.
That's to
Okay,
sustain the objection. I mean, this has nothing to do with this hearing.
With that being said, since the objection has been sustained, that will complete my testimony.
Okay.
I just ask at the end, once you've reached your decision, and I'm sure that you call me back in, if I just request that I could be given the chance to speak one last time after the decision is read, if that's okay.
Your time to speak is now, sir. Now, if there's going to be any closing arguments, perhaps.
Okay.
but If you have anything to say right now, if you're done, I was going to ask the town solicitor whether or not he had any questions for you.
By all means, let's press on then, sir.
I didn't hear you, sir.
Let's press on then, sir. Go ahead.
I have no questions for Mr. Lippert, but I do have a rebuttal witness, if you will, based on the argument regarding the Sunshine Act.
Well, before we get to that,
Mhm.
there's a question from the panel here. They want to understand exactly, Mr. Lippert, how you misunderstood the question.
To be completely honest, I was working night shift at the time. I filled out a number of these applications as of late. So I got to the first part of the question. I believe there's a comma. I assumed that I knew what the question was going to ask. That is on me. I take responsibility for that 100%. And I assumed I knew what the question was asking, and I answered it on that assumption.
What did you think the question was asking?
To be honest, I don't remember specifically in that moment what I thought the question was asking. I do apologize for
I
that.
mean, I'm reading the question here, and it's pretty clear. It says, have you ever been discharged, comma, asked to resign, comma, furloughed, comma, or put on inactive status for cause, comma, or subject to disciplinary action while in any position?
Sir, I'm not arguing with you that the question is not clear.
Okay.
I'm saying that I made a mistake because I am a human being.
All right. And in terms of the 11 different things involving discipline, do you agree they were disciplinary action?
Oh, I certainly do. Yes, sir.
Any other questions from the panel? We don't have any other questions. You have a rebuttal witness?
I do.
Okay.
All right. I'd like to call town manager. No? John Schwen. Geez, the way you looked at me. Anyway, John, you heard Mr. Lippert's testimony around the Sunshine Act, and he alleged that the town failed to advertise the September 16th meeting. Can you speak to that?
Certainly have.
John, could you?
You should probably come to the mic.
Microphone,
Hello, everybody. John Schwen, Town Manager. Here's a receipt from the Pittsburgh Post Gazette, order number 197407, run date 9-14, cost $133. Public notice hereby given that the Town of McCandless Personnel Board will hold a special meeting 5 p.m. Tuesday, September 16th, 2025 at McCandless Town Hall, 9955 Grubbs Road, Wexford, PA 15090 for the purpose of recertifying the police hiring eligibility list.
What day was it published, John?
That's published, run dates on 9-14, which is more
Sunday.
than 24 hours prior to the 16th.
So I would, is that an email, John? Is that what you're
This
reading?
is, we also get proof of publication, so if we need to enter.
Is that
copy
a
of
proof
into the
of
record.
publication you're
And
reading
this is the
from?
proof in the email, but we also
Yeah.
have a physical copy too.
Okay, so we'll make, I would ask that we mark the email and the proof of publication as exhibit 15, and enter that into the record. John can print that off for everybody and pass it out.
Thank you.
Before you sit down, court reporter reminded me of something. Would both you, and Mr. Lippert, raise your right hand? Be sworn in that the information you provided this afternoon is true and correct. So could you please swear them in? You've already testified, but we want you sworn in.
Understood. I do.
I do.
Raise your right hands.
Yep.
Do each of you solemnly swear the testimony about to give to the cause now being heard shall be the truth, the whole truth, and nothing but the truth, and so that you shall answer to God on that last great day?
I do.
I do.
And the information provided up until through the afternoon has been true and correct.
Yes.
Okay, thank you.
I have no further questions for Mr. Schwind.
Mr. Lippert, do you have anything further to present to this board?
No, sir. Thank you for your time.
All right, let's recess to executive session and we'll be back shortly.
Thank you.
Repeat the motion.
Yes, please.
Dismiss the appeal and uphold the disqualification. Is there a motion?
Make that motion.
Second.
All in favor?
Aye.
Opposed? Ayes have it.
This hearing's adjourned.
Stop recording.
Do we need to, a motion to adjourn?
Yeah, sorry, Chief, could you start recording? Yeah, keep going. Motion to adjourn the meeting. Yes, there's public comment after the end.
Look prior to adjournment.
The hearing is adjourned. The meeting is not adjourned. Yep. So is there any public comment for the meeting? All right, motion to adjourn the meeting.
I make a motion to adjourn.
Second.
All in favor? Opposed? All right, the meeting is adjourned. I need to turn this thing off.